Now I want to pick up that issue in relation to grand jury and indictments. Section 80 of the Commonwealth Constitution says a trial and indictment shall be by jury. The operative word being indictment, only three places to get it: state public prosecutors, Commonwealth public prosecutors, or a grand jury. Now a grand jury is 23 people chosen from the electoral roll. It's a closed court, and essentially the only people who are allowed in it are those who ask for the grand jury and the 23 grand jurors. And the only thing there to look at is, why didn't the government go ahead with a criminal charge? And why do you want us to look at it? Well, if we look at it, do we say, yes, that is an indictable offence, or no, it's not? Now, if 12 of the 23, which is 12 to 11, state that we agree with you that that's an indictable offence, you've got an indictment.
Of course.
And then they signed a piece of paper that says that's a legal indictment. At that point, they give it outside the door to what you call the jury's commission, or a public official, who then has to go and find that person and arrest them and place them on a criminal charge, which is from the indictment of the grand jury. This grand jury can indict a Commonwealth Prime Minister.
Exactly, yeah.
It can indict the Sheriff of Victoria. It can indict the CEO of the Melbourne Shire Council. Can the public prosecutors indict the grand jury? No. And suddenly when the grand jury sits, it's the highest authority in the country. That's why the government fears it. And that's why the government doesn't want to have the grand jury hearings, of which there's 54 of them already there.
Uh-huh.
Now, once you've got that indictment from the grand jury, the matter goes to an ordinary trial. But you can't go to an ordinary trial if you haven't got an indictment. So once you've got it not from the public prosecutor system, and in this case, the Commonwealth public prosecutor used to be Damien Bugg. But Damien Bugg was the Tasmanian DPP at the Port Arthur massacre.
Oh, God.
And I probably don't have to add to that any further.
Yeah.
So that when Damien Bugg comes into the courts, and he's not the Commonwealth public prosecutor now, he's retired, but he's facing probably 4 different grand jury applications.
Himself?
Correct.
Wow.
And that's why the government, who's actually tricking all the people, fears the grand jury, because when they put the plan together to essentially defraud every Aussie of every right they had, they forgot to take the grand jury right off the books. And suddenly the grand jury right was the only right we had left.
Yeah.
And I found it and I activated it. Now they're trying to close it. But the problem is, when you come to the word pending, pending means any matter filed or lodged prior to a purported legislative change has to be yet heard, as though there was no legislative change. Now here comes the big problem. If, for instance, they say, oh, the grand jury right was abolished, you mean by Parliament, State or Commonwealth after the Crown was removed? That point's evident.
Yeah.
So if the Aussie wants to sit and do nothing, the Aussie is actually captured itself.
Yeah.
Because they didn't understand the law. And they didn't. You don't have to be Einstein to understand this. And you don't have to jump up and down. And you don't need arguments. You just need, what document do I sign and where do I file it? And watch the government duck for cover. Now, the big one in Melton is this. Julia Gillard is your sitting member. Did Julia Gillard reveal to the electorate of lay law that she's pending a grand jury indictment hearing? Which actually means she's disqualified under Section 44. Now, there's a question under what you call nomination, Form 60 nomination form from the Australian Electoral Commission, for whoever nominates for any seat, either House of Rep or Senate. On the bottom left-hand corner is a question. Are you qualified or disqualified under Section 44 of the Commonwealth Constitution? Julia Gillard said she was not disqualified, but did not reveal the grand jury application. That would have disqualified her.
Oh, yes, of course.
Because Section 40, because the charge on her is misprision of treason, common law. Misprision of treason is the concealment of treason. But one Supreme Court judge in West Australia asked me, what is the offence of treason? I said, Your Honour, I'm the farmer, you're the judge, it shouldn't be me answering your question. He said, okay, but that's fair, but it's not the usual offence that comes across the desk, so give it to me. And at that point you have to quote law, which means an authority. You can't just make up treason. But I said treason in R versus Casement 1917 King's Bench. Now this judge knew that matter, so we spoke about that for a bit. But it says in that matter that treason is breach of allegiance. Now I said if the allegiance is breached, a criminal act of treason has occurred. Now I said here in West Australia, in the Supreme Court Act, you amended it when you enacted that Acts Amendment Repeal Courts and Legal Practice Act. But in the Supreme Court Act, you took the oath of allegiance out. That's a breach, Your Honour, with respect. You're the offender. And he goes, he just leaned in his chair and he looked at the other side, which was the Attorney General voice for West Australia. He said, if Mr. Shaw's right, I shouldn't be sitting here. They then stood up and answered him and said, if Mr. Shaw's right, we shouldn't be at this bar table. Both knew I was right, but neither wanted to admit. And then another judge said to me at a different hearing in West Australia, Mr. Shaw, if you're correct, this would have the tendency of letting all the criminals out of prison. I said, Your Honour, with the utmost respect, all the criminals are currently out of prison. Are we on the same page here, Your Honour? And he said, I understand what you mean. Now the point I'm making is, it's only a matter of looking at the acts and say, if that's your Commonwealth Constitution Act, is there an act that's breached that? Now when they took the oath of allegiance out of the Legal Practice Act in the Victoria with the Courts and Tribunals Further Amendment Legislation Act, which was enacted or done on 5th of September 2000. Now I want to give you a little reminder of some dates. On the 6th of November 1999, the Commonwealth electors said keep the Queen. But on the 5th of September 2000, the Victorian Parliament took the oath of allegiance out of the Legal Practice Act, 10 months after the Commonwealth referendum.
And the referendum was no, wasn't it?
Well, the referendum said we keep the Queen.
That's right.
We don't want that republic.
That's right.
But that legislation or bill would have been in the Victorian Parliament at the time the Commonwealth electors made their decision. So they just simply said, disregard the decision.
Disregard it.
And take it out anyway. But in taking the oath of allegiance out of the Legal Practice Act, if breach of allegiance commits the criminal offence of treason, did the state politicians commit an act of treason? That's not for us to decide. That's a grand jury decision. All we're saying, there's your accusation. They're saying, oh gee, we haven't done anything wrong and can you come to our court? I said, no, because you are fraudulently using the court now because you're not sitting under the Constitution. So you are trying to perpetrate a fraud upon the Aussie, and then you expect the Aussie to pay a court cost or demand, and if they don't, they'll see the raft of what? Because none of these are legal. And the only way you can get legal is get a republic. And you're going to force that at the next election.
Mm-hmm.
So the issue now is to block that.
Many big ideas have struggled over the centuries to dominate the planet. Fascism, communism, democracy, religion. But only one has achieved total supremacy: its compulsive attractions rob its followers of reason and good sense. It has created unsustainable inequalities that threaten to tear apart the very fabric of our society.
People in this country live with it. I don't know how the Iraqis and the Afghans live with it every single day. The mission statement of the U.S. Army is to engage and destroy. To engage and destroy. There is no nation building. There is no humanitarian operations. The mission statement of the U.S. Army is to engage and destroy, and that's what we are doing.
I know that there is pain, but you hold on for one more day and you break free from the chains. Yeah, I know that